I did mention the age of those prior juvenile adjudications. I would ask the court to consider that significantly. They were a while ago, but also Mr. Nellom was very young at the time. The notes where it indicates that he left the building were in 2013. I would ask the court to consider that. He was at most 14 years old at that time. So that's additionally, while it does indicate that anger management was ordered, Mr. Stanley-Nellom indicates that he actually completed anger management in juvenile court. That was not, ultimately did complete that. So I'd ask that the ties to Florida, it is accurate that he went to Florida for 2 years. His father was residing there at the time, and he lived with him, but he did return to New Jersey subsequent to that, obviously, where he completed high school, got his high school diploma, and got a job, started working here. So his ties to this community are much stronger and much more established, as almost all of his life he lived here.
I do find that the defense's arguments regarding the defendant's ties to the community, age of the conduct at the time of the juvenile matters, etc., are sufficient to meet the fairly low standard of preponderance of the evidence to rebut the presumption of detention. The court now has to decide whether the state has proven by clear and convincing evidence that no set of conditions, release conditions, would reasonably assure the defendant's appearance in court, the safety or protection of any other person or the community, or the third factor, which the state alleges here, though, as counsel indicated, it's not a major argument, but it does raise it about whether there be an unjustifiable risk of obstruction or attempt to obstruct the criminal justice process if the defendant would release instead. I'll start with that issue first. I understand the argument from the state, although I think what's at issue here is more of a predictive thing. If the defendant was released, what could happen with respect to obstructing this criminal justice prosecution? And I can't really think of anything, just given the nature of this case and the nature of the proof. So I don't think that's a justification for detaining the defendant. With respect to the protection of the safety of any other person or the community, I also don't think the state has proven by clear and convincing evidence that only detention would meet that goal. And I rely principally on the points made by the defense with respect to the age of the defendant at the time of the commission of the cases that were adjudicated. By my rough math, he was 14 and 15 years old at the time of the commission of those offenses, maybe even 13 at some point. He's been an adult now under the law for 2 years and has no contact with the criminal justice system. That's why the public safety assessment is what it is. However, I do find the state has met its burden of proving by clear and convincing evidence that detention is needed to reasonably assure the defendant's appearance in court when required. I rely on, among other things, the fact that because of the age of the victim in this case, if the defendant were to be found guilty of murder, and if the jury were to find that special factor about the age of the victim, he would be mandatory life without parole sentence. That is the most significant criminal sanction that exists in New Jersey since the death penalty was abolished and replaced with life without parole for the same types of cases that used to be subject potentially to the death penalty. Second, while he has established ties back here in New Jersey in more recent times, he does have ties in another jurisdiction. However, also, there is a history of failure to comply with the requirements that were imposed on him while he was a juvenile, and a couple of the violations were not when he was 13. They were a little bit older than that. So that is significant in this court's mind. The exposure, ties to another jurisdiction, history of non-compliance, including bench warrants with respect to compliance with staying in court or pending court as well. For those reasons, I am ordering the defendant detained, again, based on the risk that he would not appear in court as required. He has a right to appeal this order, must do so within 7 days under Rule 2:9-13. He is to be afforded reasonable opportunity to provide a consultation with counsel. Thank you.
Thank you.